Hi, everyone. Thank you for joining today's Benefits and Compensation University webinar. We're going to be talking about benefits issues in corporate transactions, otherwise known as Anatomy of a Deal. I'm Debbie Hoffman. I'm a partner in the benefits group. I've been in the Chicago office for my entire career. My colleagues, Stephanie Vasconcelos and Katie Dean, also in the Chicago office, will be presenting today as well. So without further ado, we will start our presentation. This is who we are.
Oh, hi, I'm Stephanie Vasconcelos. I'm a partner in the Chicago office in our benefits group, and I work regularly on mergers and acquisitions, both on the sell side and the buy side, from deals ranging from public company transactions to IPOs and spinoffs to private company transactions of all sizes. So looking forward to talking to you today about some of those issues on the benefits front.
And I'm Katie Dean. I'm a counsel in the Chicago office as well. And I work on all sorts of M&A matters, as well as finance transactions. And I'm also working with our new rep and warranty practice in the firm, which I'll discuss later.
Okay, so you will see an outline slide which kind of outlines what we're going to be talking about, just as a kind of a table of contents. And the thrust of the program will be that we're going to be talking about issues that are likely to come up in corporate transactions in the benefits area. And we're going to do it in such a way that we're going to kind of walk you through what a purchase agreement might look like and the various sections of the purchase agreement and issues that might come up within those sections. We're going to be talking about the main parts of the agreement, and we're not going to get into a lot of, the weeds, because there's plenty of issues to go around at a higher level. Next slide, please. So unlike just a few words in advance of getting into the substance, unlike many areas of employee benefits where there's a lot of law that governs everything, corporate transactions are more like an art with a little bit of science thrown in, and science would be the law. We certainly have to know the law, and we have to understand what the legal issues that come up. But how the deal is actually done is done a lot of times by the business people and the legal team and the HR professionals that are working on the transaction try to implement what the business team wants to do in the transaction. Therefore, we can't provide you with a checklist of every issue that might come up, because every deal is different and the issues are different with respect to the various parties. But we can talk about the common issues that arise, and that's what, as I said, we're going to talk about today. Next slide, please. So we thought it might be a good idea to kind of set the table with the structure of various transactions so that we then can see how the issues fit in. So we'll talk for a few minutes about the types of common transactions that we might see. The first one is an asset sale or purchase, which is one where one party is selling assets to another party, unrelated to them usually. And sometimes we have to be careful with those because assets can include stock. And if the assets include stock, then we have to also look at it sort of as a stock transaction as well as an asset transaction. Another kind of common transaction is a stock purchase. It's similar to an asset purchase. This is where one party sells stock to another party. And that could be all of the stock of the target. It could be some of the stock of a subsidiary or some of the stock of a target, or it could be stock of a related company. We frequently ask in the transactions, and you'll see why when we continue to talk about how much stock is being sold, because that's very important in the benefits area to determine whether there's successor liability or joint liability that's coming with the stock. And so we typically are much more concerned in a stock transaction or an asset transaction where stock is a component about the liabilities of the target that are being acquired. Next slide, please. A merger is similar to a stock transaction. It's where one company is being merged into another company, and these transactions raise a lot of the same issues that a stock transaction raises. There's different kinds of mergers. We'll start out talking about some of the ones that are less common. One is a direct merger where a company merges directly into another. So company A merges into company B. This is not very common, but it does happen from time to time. Another kind is a forward triangular merger. And the three sides of the triangle are the acquiring company, a subsidiary of the acquiring company, and the target. And in the forward triangular merger, the subsidiary of the acquiring company acquires the target merges into the subsidiary, and the subsidiary remains the outstanding company. This too is not overly common, and the reason is because if you merge the target into the subsidiary and the subsidiary survives, you have to figure out what to do with all the target's contracts and benefit plans and so forth, and they may need to be assigned, and it creates a lot more issues than the next one we're going to discuss. Next slide, please, which is a reverse triangular merger. In this kind of a transaction, which is the most common form of a merger, a company will form a new subsidiary to acquire the target company. The target company merges into the subsidiary, and the target is the survivor of that merger. So all of the target's arrangements continue in its new form as a subsidiary of the acquiring company. Next slide. There's a few other transactions that I'll just mention. We're not going to talk about them a lot today because they're usually evidenced by different documents than we're going to be kind of using as our backdrop, but a lot of the same issues arise. And since you may have heard about these transactions, we want to make sure that you understand kind of what they are before we get into a detailed analysis of the issues. One is an initial public offering, sometimes called an IPO, where a company offers its stock for sale to the public for the very first time. A spin-off is the creation of an independent company by an existing company by taking shares and distributing them out to third parties, usually their own shareholders, either via a dividend or some other method. So that when the spin-off is done, you now have two companies where before the spin-off you had one. The third type of a transaction is called a SPAC. These are becoming more and more popular. Special purpose acquisition company transaction. This is a transaction where a company does an IPO or an initial public offering to raise money to invest in either a specific target or a specific industry or a specific geographic location. They take the money that was invested from the IPO and through a series of transactions with the target, merge the company in, their target company in, so that when the SPAC transaction is done, the target company becomes the public company that they had formed with the IPO. Next slide. So once we know the structure of the transaction, then our next step is to do due diligence. Typically, an acquirer is going to have a lot more interest in doing due diligence than the buying company because they want to find out what the target company has, what kind of liabilities are there, what kind of issues are there, what costs are there, so that they can make sure that there's nothing lurking that they haven't taken into account in valuing the company. Sometimes a target company will want to do due diligence on a buyer because maybe stock is part of the consideration in the transaction. And if they're going to be getting stock of the acquiring company, they want to know what could affect the value of that stock. Also, a buyer and a seller have to do due diligence on their own plans to make sure that they can integrate the businesses properly, and they need to disclose what kind of liabilities they have and what plans they have. So there's a lot of due diligence that goes on across the board.
And you sometimes see sellers wanting to do diligence on buyers' plans if the buyers are saying, hey, our plans are what are going to cover seller employees after closing, and seller may want to do a deep dive into buyer plans to really get comfort with whether that's acceptable or whether they need to push back or create some special covenants for that.
Right, exactly. Next slide. Then simultaneously with the due diligence, sometimes before the due diligence even starts, the operative agreements are starting to be formed. And that's where our focus is going to be today, is the provisions that go in these operative documents. You can kind of think of them as the blueprint of the transaction, because they explain what the transaction is, so we know what kind of a merger it is, or a stock purchase or asset purchase, what the consideration is going to be, and every topic that the company might have: real estate, IP, and of course the most important provisions are the benefits and HR provisions. Those are in there as well. So we're going to kind of walk through the significant provisions of an agreement, and the provisions are kind of usually included in all types of agreements, so they're symbiotic across the various kinds, and address some of the high level issues that come up in these various places. We put on the slides kind of the issue or the areas of the purchase agreements that we will be talking about, starting with equity treatment and conversion. Next slide. So equity treatment is in a transaction is very important, as evidenced by the fact that it's usually included right at the beginning of the document after it talks about what they're paying for the stock or assets. The next thing that they talk about is how the equity awards are going to be treated. If a selling company has equity awards, they have to be addressed in the purchase agreement, unless it's an asset sale where the awards are going to stay in place or the target is just going to handle them on their own. But in any type of a stock-based transaction, almost always there's an equity provision in the agreement. One of the first steps in determining what the agreement is going to say about it is looking at the operative equity plan and the award agreements to see what they provide for in the event of a change in control or corporate transaction. Because you have to know what the contractual obligations and alternatives are before you can decide what you put in the agreement. Another early step, and usually done together with what the contracts provide, is what the parties want to do with the awards. Sometimes there's a dispute about that, but at some point the parties come to an agreement about how they want the awards to be treated, and then we have to make sure that that is how the agreements and the plan permit the awards to be treated. Things to consider in determining how the awards would be treated is, are they going to be canceled and paid out in the transaction? What's the consideration going to be? Is it going to be whatever the consideration is in the deal, cash, stock, something else? Are only vested awards going to be cashed out? Are non-vested awards going to be continued? Are they going to be canceled? Is there going to be accelerated vesting, either by the contract or by the agreement of the parties? Another approach would be, are the awards going to be assumed by the acquiring company? This happens sometimes, particularly if it's a public company that's acquiring them and they have an equity plan in place. It's a fairly easy process for them to assume the awards and convert them to awards on the acquiring company going forward. Next slide. There are a lot of concepts to keep in mind relating to equity treatment in a transaction. One is, if the desire of the parties is not consistent with the plans and the award agreements, sometimes you have to get consent of the holders of the equity in order to give the treatment that the parties want. If the awards are to be assumed by the acquiring company and converted into new awards of the acquiring company, then the holder of that award cannot receive more value in the conversion process than they had immediately prior to the awards. And if the awards are deferred comp, which means they're subject to Section 409A of the code, then we have to be really careful about the conversion, because we want to make sure that the conversion doesn't either make something that wasn't subject to 409A subject to 409A, or violates the Section 409A rules relating to payment timing such that the individual ends up subject to an excise tax. We're not going to be talking a lot about Section 409A in as far as substance, but you'll hear us talking about that term a lot. And if you've talked to a benefits lawyer at any point in the last 15 years, I'm sure you've heard the term. But generally, Section 409A covers pretty much any type of compensation, and we always have to worry about it because, as I mentioned, the penalties for failure to comply, whether in the document or in operation, are very dramatic, and they fall on primarily the individual, although the company has a reporting obligation, so it's in everyone's best interest not to screw it up. Next slide. As I mentioned, the valuation and payment timing rules are very important. That is why benefits lawyers spend a lot of time looking at all of the agreements, because we have to figure out what the payment timing was before the transaction. Is the current payment timing or desired payment timing consistent with that, or can we find an exception such that we don't violate any of the rules relating to the conversion? For example, it may be possible to change the payment timing from termination of employment to cashing them out on the transaction, but that's not always a given. If there's options and SARs, then they're typically not subject to 409A, and we don't want to do anything to make them subject to 409A. So that's what we're worrying about in the equity conversion arena. Next slide. Here's a couple examples of things that we have to be concerned about. As I said, the option in the conversion, there will typically be a change to the exercise price, because if there's a conversion of the award, they're now getting different stock with a different price. And the number of shares may also need to be adjusted. And so we need to make sure that after the exercise price and number of shares are adjusted to the new award, that they don't have an increase in the spread between the two based on what it was immediately prior. And RSUs are typically a payment timing issue. Next slide. If the award is to be paid out in connection with the transaction, so not converted, now we're going to pay it out, we have to give consideration to what the tax treatment and the payment schedule is going to be, because we don't want to change the payment timing schedule again unless it's permitted under Section 409A. Almost always the payment of an equity award that's being paid out in connection with the transaction is going to be taxed as compensation, because the awards were given in connection with the performance of services, and so it's going to be subject to withholding. The easiest way to do that, of course, even though the money is coming from the proceeds of the transaction, is to run it through a payroll system, because it's already set up to take the withholding. That just requires practicalities to make sure that there's a payroll system that can run the payments and do the proper withholding, but it's something that shouldn't be lost or wait till the last minute, because sometimes we find out at the 11th and a half or 11th hour and 59 minutes that there's no payroll system, and everybody is, running around trying to figure out how we're going to do the withholding. So just a heads up issue there. Next slide. Another common feature relating to equity awards and the deals in general are earnouts. And these raise interesting and usually complicated and hair-pulling out type questions as to both the payments that are coming out and the tax treatment of the earnout. A typical earnout, sometimes they're called escrow payments, but same difference, that is paid over a period after the transaction closes, usually based on performance, but sometimes based on continuing employment. And merely by definition, the payments are going to be paid over time, so we have to worry about our deferred comp issues under Section 409A. And whether or not the payment timing of that earnout satisfies Section 409A or is exempt. Payments relating to a change in control that occur because a company is buying out a stock right, which for 409A purposes is limited to stock options and SARs, or that is based on the value of the company's stock, so an RSU, restricted stock, and so forth, is subject to special rules under Section 409A, referred to as performance-based, transaction-based compensation rules. Next slide. Transaction-based compensation under the 409A rules satisfies the payment timing, so we don't have to worry about the application of Section 409A, if that earnout or the transaction-based comp is paid on the same schedule and under the same terms and conditions as applies to shareholders generally in the transaction, and if it's paid within 5 years after the transaction closes. That's usually satisfied because normally earnouts don't go for more than 5 years, but it is something we have to look at. And also, we have to make sure that it's actually paid on the same terms and conditions. It's also possible to subject transaction-based compensation to vesting conditions that weren't there prior to the transaction. Normally under Section 409A, if you add a vesting condition to certain compensation, it's disregarded for purposes of doing the 409A analysis. So this is a very important exception because you can add it to transaction-based compensation and possibly take the entire piece of compensation out of 409A. So very important exception. Next slide. Issues relating to the taxation of earnouts also arise in connection to payments to management employees or employees of the shareholders who become employees of the acquiring entity following the transaction, where the right to the earnout may be tied to their continuing employment. The goal of a seller, or whether it's a shareholder, equity holder, whatever, will be to defer tax on the earnout until the payments are actually received, first of all, and to, in a perfect world, to have the payments treated as deferred purchase price, which gets capital gain or loss treatment, rather than compensation income, which is taxed at ordinary income tax rates. It's subject to withholding tax. It factors into the 280G analysis, which we're going to talk about later. The deferred comp rules apply, and all of the quote unquote bad things that we worry about with comp. There is no correct treatment, but to the extent we want to call it correct treatment, really depends on the facts and circumstances and negotiations of the parties over the facts and what they might be and what law should actually apply to it. Next slide. Some factors to consider is whether the payments are based on factors that are traditionally used to determine employee comp. Is it tied to their service? Is it similar to the individual's prior wages? Is it making up for wages that they would have otherwise received? If they're getting a full compensation package and this compensation is just on top of that, it looks more like deferred purchase price than it does compensation. And so you might have a better chance of taxing it as deferred purchase price and not subject to the compensation rules. And there's some other facts on the slides about things that people take into account in determining the tax treatment of the earnout payments. Next slide. Another concept that's closely related to equity awards is rollover equity. This is sort of similar to an earnout, except for rollover equity is a common feature that is reserved for management sellers that are rolling over their actual equity in the transaction into an equity award of the acquiring company. It generally involves the equity management's shareholder taking their existing shares and exchanging them for shares of the acquiring company that are restricted in some fashion. They and usually are earned then based on continuing employment of the selling equity shareholder with the acquiring company. The restricted equity would typically be subject to tax under Section 83 of the code as compensation income when it vests. But there was a revenue ruling issued in 2007 that provides that you can kind of avoid that treatment and certain steps are followed. Next slide. The process that would be followed to get that treatment it's kind of backdooring your way into the treatment. So the selling management shareholder would make an 83B election, which is an election to be taxed on the value of the acquiring company restricted stock at the time it's granted, so in connection with the transaction. And they are taxed on it, but the tax value is zero because they have paid for it by exchanging their existing equity of equal value. So they're taking vested equity, exchanging it for unvested equity of the same value. The 83B election says, tax me at the value of the shares I receive less what I'm paying, which is zero. So there's no tax at the time they make the election. And then when the shares actually vest, there's no taxation because they've already been quote unquote taxed. And when they dispose of that restricted stock, then they get capital gains treatment on it. The revenue ruling, it addresses only stock rollovers, although most practitioners think it applies to other types of restricted property because 83 covers other types of restricted property. Such as the LLC agreement, LLC interests, and other types of interests. Recently, we've been getting some postulations that it should apply to other things like cash, but 83B election doesn't apply to cash, so it's kind of hard to get there, although it hasn't stopped people from suggesting it, shall we say.
So we're moving on to the reps and warranties section. So just to start with the basics, representation and warranties are assurances that are provided by a seller about the condition of the target company and its benefit plans and comp programs. So the seller is then going to have to disclose any exceptions to the reps on the disclosure schedules that relate to the purchase agreement. And then the buyer will either have indemnity protection in the agreement against a seller's breach, which Stephanie is going to talk about indemnities later in the program. Or as I'll discuss a little later, the buyer might want to rely on rep and warranty insurance to recover any losses related to a breach. Reps are also a really great way to uncover information for due diligence. And this is particularly true for operational failures that are kind of harder to diligence based on documents alone. Buyers can also get information on how the seller is interpreting certain benefit plans or arrangements. It kind of, as Debbie mentioned before, there's typically a rep that requires disclosure of compensation or benefits that are going to be triggered in connection with the transaction. So the seller is going to need to analyze their arrangements for any change of control provisions or other payment triggers, and they need to come to a conclusion on whether the proposed transaction structure is going to apply to that. And that, again, would show up between the reps and the schedules. So it's another good check there. So in a typical purchase agreement, there's usually a separate section of reps related to specifically to employment benefit matters. But then there are reps and warranties that are related to benefits issues that can be found in several other areas of the agreement where there's crossover. So some examples of that: labor employment reps can sometimes cover wage and hour issues, proper payment of compensation to employees, classification of employees. The tax section can often include reps on 280G, which Stephanie will discuss a little later, and then the deferred compensation rules under 409A, which we will continue to talk about all the time. Material contract section typically lists employment agreements or other individual change of control arrangements. There's typically reps in absence of changes, which covers any changes to benefit plans or new benefit liabilities that might have popped up since a particular look back date that's usually tied to recent financial statements. And then the capitalization reps, which talk about outstanding equity awards. Next slide. So going back to the actual employee benefits section, reps typically cover the definition of benefit plan and the list of the documents that are provided to the buyer. And here, the parties need to be careful to address all the plans that could impact the buyer. So for instance, certain types of benefit plan liabilities are joint and several among controlled group members. That's the 80% threshold that Debbie was talking about earlier, generally speaking. And where members don't maintain or participate in the plans directly, they can still have liability to those plans. So that goes for defined benefit plan minimum funding requirements or termination liabilities, multi-employer plan liability, COBRA. So there are a few other things that can sort of span beyond your target that you want to make sure are picked up, and the buyer has an interest in understanding their exposure to those plans.
And Katie, in the reps and warranties, this may be one area, the actual reps and warranties, where an asset deal and a stock deal might differ a teensy bit, because what we're really trying to pick up is liabilities that the acquiring company is going to have. And if they're not taking on the benefit plans, it's harder to justify a 4-page benefits rep.
Right.
We try.
That's exactly right. Yeah, the scope and tone definitely depends on the deal structure. So when a stock deal or a merger where the benefit plans are inherited by buyer, the reps are going to be significantly broader, more detailed. In an asset transaction, if you're leaving everything behind, generally speaking, the scope tends to be much more limited. We see a lot more materiality qualifiers, knowledge qualifiers, look back limitations, that sort of thing. So we also have usually a general compliance rep in both stock or asset transactions. Again, in the stock transactions, you'll often see additional specific compliance reps to really go into the weeds there. So you'll cover things like plan qualification, Affordable Care Act compliance, 409A, COBRA, prohibited transactions, reporting, disclosure, timely payments and contributions, those sorts of things. And then, as I mentioned before, there's typically a transaction benefits rep dealing with any sort of payments or benefits that are triggered in connection with the deal, and Section 280G, which I'll turn over to Stephanie, and we'll come back to this slide in a minute.
Yeah, so next slide. Section 280G is something that regularly comes into play on transactions. And frankly, we could do a whole nother session just talking about the ins and outs of Section 280G, but instead we'll try to tell you, some high level things to know in 2 or 3 minutes so that you're at least aware of some of the issues. Where Section 280G comes into play is where there's a corporation undergoing a 280G change of control, and that change of control triggers payments or benefits for so-called disqualified individuals who are generally officers or more than 1% shareholders or certain other highly compensated individuals. And if those individuals are receiving these payments or benefits in connection with the change of control, and those benefits exceed a threshold, which is based on their compensation, their average compensation over the last 5 years, then a portion of the payments is subject to a 20% excise tax, and the corporation loses its deduction for making those payments. So, bad consequences all around. It's generally in the recipient's interest to try to avoid the excise tax and the company's interest to avoid losing its deduction. And so there are exceptions to these rules, and the one that we want to at least briefly highlight is the shareholder approval exception, because that's the one I think we see used most often. Next slide, please. The basic principle of the shareholder approval process is this. You have the disqualified individuals who are receiving these parachute payments irrevocably agree to waive any payments that are in excess of their threshold. So, for purposes of this very short discussion, assume that their maximum payments could have been $300,000 and someone was due to receive a $500,000 change of control bonus. That individual would say, I agree to waive that extra $200,000 worth of change of control bonus unless the shareholders approve it. Once that waiver has happened, you then take all of the information about these parachute payments to the shareholders of the company undergoing the change of control. And in that process of determining the shareholders in itself can be very complicated. It's not necessarily just the first level of shareholders. There are rules about passing through the votes to, those entity shareholders and so on and so forth. But those shareholders have an opportunity to review and determine whether they approve that extra $200,000 payment. And if they do, if they see it and say this is fine on our end, then the payments can be made, and it's as if 280G didn't exist. There's no tax, no 20% tax, and there's no loss of deduction. If the payments aren't approved, then the individual doesn't receive that $200,000 payment. And again, you don't have the tax and you don't have the loss of deduction because now the payment hasn't exceeded the threshold. One important thing to know about this part of 280G, this shareholder approval process, is you can't tie the transaction to shareholder approval of parachute payments. So you can't say this transaction only goes through if we also get shareholder approval of parachute payments. The votes need to be independent from one another. What you can do, and what we often do in purchase agreements, is include language in the covenants saying that the seller or the company undergoing the change in control will seek waivers from disqualified individuals related to any parachute payments they may receive. And then to the extent they get those waivers, they will seek a vote from all applicable shareholders and give them the information they need to make a vote that qualifies under 280G and have that process all finished up prior to closing. So again, it's not contingent or conditioned on the transaction, but all of the mechanisms are in the document so that they actually conduct the vote, whether favorable or not. All right, Katie, I'll turn it back to you.
All right, if you can go back to the, there we go, perfect, thank you. So a few other topics that are covered in the employee benefits rep section. We'll make sure that there are no outstanding litigation claims, audits, or investigations by a government agency. There's typically reps confirming that there are no benefit plans of certain types that are generally associated with higher risk and higher cost, like plans subject to Title IV of ERISA, multi-employer plans, which are the union plans, multiple employer plans, which are 2 or more unrelated employers, and multiple employer welfare arrangements, or retiree medical liabilities. Again, if these types of liabilities exist, there's typically another whole chain of reps that you want to get related to the health and funding of those types of plans. And then finally, we typically see a rep that there are no limits or constraints on the ability to amend or terminate the plans after close. Okay, we can move past the 280G slide. Thank you. Okay, moving on to rep and warranty insurance. Okay, so rep and warranty insurance, it's designed to protect a party from financial losses resulting from a breach of the representations about the target business. So employee benefits coverage typically lasts 3 to 4 years following the closing of a deal. Next slide. So just to back up a little bit, rep and warranty insurance is a relatively new vehicle. It's one of the biggest trends in M&A in a very long time, and there's really no signs of it letting up or reversing. A deal without rep and warranty insurance, or at least without considering whether to get it, is definitely the exception these days. The rep and warranty market is actually so busy that underwriters are turning away deals, which is just crazy. The use rate in private equity deals is very high. Strategic acquirers, though, are catching up. So parties have various reasons for wanting rep and warranty insurance, including, an insolvent or financially unstable seller, a desire for a cleaner break at the closing, reluctance to put proceeds in an escrow, or just generally improving the risk profile of the deal. And you can see on the slide, I have some specific buyer and seller advantages. So the buyer with a rep and warranty policy will tend to get broader reps and warranties, better indemnification, so longer coverage, and fewer limitations. It'll avoid post-closing adversarial proceedings with the sellers. And it also often results in easier claims process because of the reputational considerations that the underwriters have. And then on the seller side, it's just a cleaner break. They have a lower cap on what they need to cover for indemnities post-closing, and it avoids trapping funds in escrows that might have low interest rates. Next slide. So while buyers will want to make sure as much as possible is protected under the rep and warranty policies, there's typically some exclusions, and they come in two forms. So first, they come in standard policy exclusions, and then they also come in transaction-specific exclusions. So the transaction policy exclusions depend on the underwriter generally. They often include losses related to pension underfunding and multi-employer plan withdrawal liabilities. We see a lot of carve out of new and uncertain areas of law, so COVID impact or the application of the new government relief programs that aren't so clear yet. And then future or forward-looking reps are typically carved out. They don't want to insure something that hasn't happened yet. So these are typically noted in the non-binding letter of intent from the underwriter at the very beginning of the process, and usually those aren't up for negotiation. It's kind of their standard. On the other hand, transaction-specific policy exclusions are based on the actual diligence and the language used in the rep and warranties. So the underwriter will typically have, they'll review the written diligence reports. They'll have a call with buyer's counsel to assess the deal specific issues. And often there's the ability to go back and forth to get more information and sort of negotiate out the proposed exclusions. So in general, the less thorough the diligence, the broader the exclusions under the rep and warranty policy. So the more detailed, the more thorough the diligence report is, including quantitative estimates of the exposure, tends to typically narrow exclusions. It's important to keep in mind that a materiality threshold for a rep and warranty exclusion is often less than what would be considered in sort of the broad scope of the deal. Also, one other thing that's often carved out is issues that buyer is aware of before the deal goes. So it's just something to be aware of. It's kind of an odd dynamic there. So now I will pass it over to Stephanie to discuss interim covenant.
Yeah, so once you get through in the purchase agreement, the rep and warranty section, you often have a section on interim covenants. This section is not necessary in all deals. You have some transactions that have a simultaneous signing and closing, which means that the parties are signing the purchase agreement and closing the deal on the same day. However, in many deals, maybe in most of the ones that we work on, there's a period of time between the date the parties sign the purchase agreement or the merger agreement and the date on which the deal actually closes. And that period of time is usually to allow for, HSR filing or other regulatory approvals or third-party consents or just, any other pre-closing matters that may need to be dealt with after the parties have come to a definitive agreement. So the interim covenants govern how the seller or the target can operate between signing and closing. And they are generally in place to give the seller some guidelines on what they can and can't do. You wouldn't want a seller to be able to go in and increase employee salaries by 100%. And for the same reason, you wouldn't want them to be able to go in and cut employee salaries entirely. You generally want them to continue operating their business in the same manner in which they've done it up until the date where you've signed the purchase agreement. So the interim covenants will cover all manner of issues, and some of those will be benefits issues, including restricting things like increasing salary and benefits, hiring employees, firing employees other than for cause, awarding equity and equity-based compensation, accelerating vesting or funding of benefits or plans, all without the buyer consent. Now, there are exceptions here, some that'll be written straight in the purchase agreement and others that might be scheduled that are more specific. The general exceptions may be things like hiring employees to fill open positions or hiring employees with a base salary less than $100,000 or $75,000, whatever is appropriate to the business, or increasing salaries in the ordinary course of business, or continuing with your bonus awards consistent with the plan that's been adopted for any given year. Other exceptions that you see that might be more specific are typically detailed on a schedule. For example, you might see the parties agree that a seller can implement a retention bonus program that's very specific to retaining employees in connection with a transaction. And there, the schedules can be very detailed. It might give the size of the bonus pool, the maximum amount of award for any particular employee, definitions of good reason and cause that might be included in the plan, I've seen form award agreements included. You really can get very technical, or you can get very general. So those are the types of things that we see covered by the basic interim covenants. Next.
And Stephanie, one of the tensions a little bit is that you don't want to give somebody else too much control over how you operate your business, but the other side doesn't want you to give away the store either. That's really the tension of what's going on there, right?
That's exactly right. You want them to continue to be able to do their operations and not to have to come to you every time they need to give somebody, a promotion or a bump up in salary. But you need to have guidelines so that you don't find out they've gone in and implemented a brand new severance program that no one knew about or talked about or something.
Right. And I see you're going to talk about gun jumping, which is kind of related to that.
Exactly. Gun jumping is something to keep in mind in transactions, and we're already on the next slide. Especially where the seller and buyer are actually competitors. And this comes up both in diligence and in interim covenants. At the most basic level, the concern is that the parties could be sharing competitively sensitive information, or they could be coordinating their conduct in some sort of anti-competitive manner. And so for that reason, we work really closely with our antitrust colleagues, whether we're on the sell side or on the buy side, to make sure that information that is put in the data room is okay to disclose for antitrust purposes, or that, when we're sharing employment or benefits related information, it may be limited to even a smaller subset of the people in the data room than the general data room. And then when we're looking at interim covenants, the antitrust people get involved as well to make sure that the buyer doesn't have too much control over the seller's business before they actually purchase the seller's business. Because while, of course, you'd like all deals that sign to close, that doesn't happen for all transactions. So you need to be careful there. A couple of other interim covenants that we have mentioned on the slide. One is non-compliance corrections. And so Katie talked about diligence, where you may identify certain issues, whether in documents or in operation. If there are issues that you've identified that are possible to clean up prior to closing, we'll sometimes include covenants asking the seller to remedy those or to use commercially reasonable efforts to remedy those. That's not every issue. Not all issues can be fixed in the weeks or months prior to closing, but some can be. For example, an employment agreement with bad 409A release language can often be cleaned up fairly easily with an amendment to the employment agreement. So consider any issues that you may want cleaned up and whether it's worth including an interim covenant on that note.
And whether it's prudent, because if it's a publicly filed document, you might not want to put a bunch of non-compliance things on a schedule that someone is going to see.
Absolutely.
Someone being the IRS, for example.
Sometimes it's much better to have handshakes to deal with things.
Right.
We've already discussed 280G, but of course, if you're doing a waiver and a vote process and there's an interim period, we would normally include a clause addressing when and how the process is to be conducted, and requiring that the whole process be wrapped up no later than the day prior to closing. Though usually I at least add in a few extra wiggle room days in case, anything's going awry with trying to contact shareholders or get signatures and so on. And then one other issue that usually is addressed in the interim covenants between signing and closing is 401k plan terminations. Next slide, please. You'll see that a very common provision in purchase agreements is a provision that requires the seller or the target to terminate its 401k plan prior to closing. And this is because, while money in a 401k plan can be distributed in connection with a plan termination, that can't happen if the employer establishes or maintains another defined contribution plan at the time of termination. So that means if the 401k plan termination happens immediately prior to closing, and assuming the seller or target company doesn't have another 401k plan in place, those distributions can be made. However, if termination is made after closing, when the buyer has another defined contribution plan, which it typically does, distributions couldn't be made from the seller plan, even if the plan were terminated. You'd have to leave it open, freeze it, merge it. All of those raise complications over time. So I find the very common approach in stock deals is to request the seller terminate it prior to closing, just so people can roll their money over into a buyer plan or into whatever other plan they choose.
And termination for this purpose doesn't mean distribute the money. It just means that it's frozen to new contributions, it's terminated in a legal sense.
Right.
And then it's often conditioned on the closing because, again, the closing may not occur.
Exactly. Termination for these purposes is really signing a set of resolutions, and none of the actual admin work happens until after closing. But next slide, please. One issue that we want to flag that I think all three of us and our colleagues see pretty regularly is, even if you are permitted to make distributions on a plan termination, you also need to consider the consent rules, which generally require participants to consent to 401k plan distributions if the amount is above the small cash out limit, which is usually $5,000 in plans. While normally you wouldn't need to consent to a distribution on a plan termination if it didn't offer annuity options. Next slide, please. There are rules under section 411A11 that state that the no consent rule doesn't apply if any member of the controlled group maintains another defined contribution plan. And unlike the rules we just talked about, where we talked about plan termination, 411A11 doesn't state that that's tested at the time of termination. It's left open, suggesting that you actually have to test it when the distribution is going to be made, which in our cases, in transactions, the distribution is made after closing, when there is almost always another defined contribution plan within the controlled group. So for that reason, we advise that you need consent to roll balances that are above that small cash out limit, but we often see people advising, and especially TPAs, that you don't need consent, that you can just roll everyone right out of the plan. So it's something to be very mindful of as you're dealing with a terminated plan in any transaction. And with that, I'll pass it over to Katie to talk about some of the other employee covenants we see for post-closing.
All right, so post-closing covenants address what happens to the in-scope employees after the deal closes. And this, again, depends largely on the deal structure. So in an asset transaction, employees will generally terminate employment and then must be offered employment by the buyer. So it can trigger severance, benefit forfeitures, payouts, accelerated vesting. So something to be aware of. And again, analyze the plans that apply to see what happens there. Consideration also has to be given to employees that are out on disability or another leave of absence. Often it makes the most sense to have those employees remain behind until they're able to come back to work so that they continue receiving benefits on like a seller parent plan or something. In a stock transaction or a merger, the employees that are employed by the target or further down the chain will continue their employment uninterrupted. So if the in-scope employees are employed by a parent or another entity other than what's being acquired, the parties typically want to move the employees that are in scope via intercompany transfer prior to the close so that they don't experience that termination of employment. And the movement of employees and the offer and acceptance process, that will all be written out in the purchase agreement, typically with the certain conditions on, you know, do we have to see the offer letters before they go out, and, you know, who can you make offers to, and which employees do you need to move into the target business. Those will all be issues that are addressed in the purchase agreement. Next slide. Regardless of the transaction structure, the agreement often includes employee protections for a period of time following the closing. We rarely, if ever, see it over 2 years, but 1 year is very common too. The covenants typically include a promise to maintain certain levels of salary, bonus opportunity, benefit plans, and allow the employees to remain in a particular geographic location. We often see carve-outs for requirements to preserve equity or long-term incentive compensation, defined benefit plans or retiree welfare benefits. But again, this depends on the compensation structure and how it would impact the employees going forward, as well as what benefit plans buyer has in place on their own platform, because sometimes it's just not possible to promise mirror plans going forward.
And sometimes you see a special protection on severance separate and apart from the benefits.
Yeah. Right. And that can even sometimes include a whole schedule that they agree on for purposes of the transaction. These people that are going over now will get this severance if they leave within a period of time. So for the benefit plans protection, that's typically measured on an aggregated basis. So the value of their overall benefits package, and that can be measured against what employees were receiving from the seller immediately prior to close, or they might be measured against what a buyer would provide to its own similarly situated employees. Next slide. Some other employee protections include service crediting, meaning they honor the time that the employee was employed by the target or its predecessors for certain purposes under the benefit plan. So vesting, eligibility, benefit accrual. Depending on the types of plans involved on both sides, there's often carve-outs, again, for certain benefits. So most commonly, service would not be credited for purposes of defined benefit plan accruals or retiree welfare benefits under buyer plans. The covenants also often provide for waivers of waiting periods or evidence of insurability requirements or pre-existing condition limitations to the extent those apply. And then in the event of a mid-year deal closing, the covenants might require the buyer plans to honor the amounts that the employees have already paid out during that plan year. So for co-pays or deductibles, or any out-of-pocket expenses under the seller plans before they move over to buyer. Next slide. So what's said in the post-closing employee matters covenants is very important and can have an impact on what rights the employees might have based on the language. So there's typically what's referred to as the no third-party beneficiary provision in the employee matters section. And this provision would make it clear that the employee covenants don't create any third-party rights. They don't amend any benefit plans or require the continuation of any specific benefit plans or provide any rights to continued employment. I'm just going to go over a case really quickly that illustrated this. This is the Halliburton case where there was a merger of Dresser into Halliburton. And in the merger agreement, there were provisions about what was to be done with the benefit plans after closing. There was a 3-year protection period for active employees, but no specific time period for protection of the retiree medical benefits. So after about 6 years after the closing, Halliburton amended the retiree medical benefit plans and the retirees sued. And the court ultimately held that the purchase agreement was an effective amendment of the retiree plan. And so that restricted Halliburton's ability to ever amend the plan. And the court further held that the no third party beneficiary language didn't preclude the participants from making the claim because they were making the claim under the plan as amended, not under the merger agreement. So as a result, we now recommend adding this language that to the effect that the covenants don't amend the plan and they don't restrict the company's abilities to amend the plan, and they don't provide any third party rights to enforce. So now I'll turn it back to Stephanie for cafeteria plan.
All right.
No, next slide.
So now we're kind of delving into a laundry list of other post-closing covenants and closing related issues that you might see that are related to benefits. One of those is cafeteria plan transfers. And I have to admit that I find that the appetite to address this issue is generally pretty low because the way you address it is fairly complicated. The issue is that cafeteria plan rules generally prevent participants from changing their elections mid-year unless there's a change in status. And while there are some times where a corporate transaction that's an asset sale will be a change in status because you'll have a termination of employment, that doesn't help the fact that employees may be leaving very large balances behind with a seller plan, and it doesn't address situations where, for example, you may have acquired a subsidiary where a parent maintained the FSA plan. So there are a lot of situations there where you've got unhappy employees who've got an FSA balance left somewhere. They can only spend for the portion of the year where they contributed to that FSA. And while there are methods, and they're prescribed by this revenue ruling 2002-32 to work on transitioning those flexible spending account balances, they are fairly complicated. So you have to worry about transferring the balances, considering whether and how you will treat which side may have been overdrawn for any part of the calendar year or the plan year in which they occurred. You have to deal with times where a buyer and a seller might have FSA plans that run on different years. Maybe one's a calendar year and one's a July 1 year. So, I think it's worth at least considering in transactions and looking at whether there are employees with significant balances or where there may be a big impact. Some of this can be mitigated by counseling employees upfront if there's a period between signing and closing. And then considering whether there are any things that you may want to do under 2002-32 to either allow them to continue existing FSA elections with the seller or to roll over any balances to the buyer.
And some of these issues have been somewhat mitigated since 2002 by the ability to use a longer period to make claims under cafeteria plan rules as well, right?
Yeah, absolutely. And some of them have been mitigated during COVID as well. There's a lot of flexibility that isn't typically present for flexible spending accounts. I don't expect that that's going to remain out there forever, but at least for transactions happening now, we see a greater amount of flexibility in the regulations governing cafeteria plans. All right, next slide, please. So another thing that we sometimes address in the employee covenant section is W-2 reporting. This won't be an issue in stock transactions where individuals remain employed by the same entity over the course of a calendar year. They'll just get a W-2 from that one entity over the course of that calendar year. However, it will be an issue in other transactions like asset purchases where employees will work for more than one employer over the course of that year. The so-called default rule is where each employer issues a W-2 to the employee reflecting the wages and benefits that that employer paid to the individual. But there is an opportunity, and you can go to the next slide, in the context of certain corporate transactions to use what's called the alternate method. That special procedure is provided under Rev Proc 2004-53. And by its terms, it only applies to pretty specific circumstances when an employer, which it calls the successor, acquires substantially all of the property used in a trade or business of another employer, the predecessor, or used in a separate unit of a trade or business of a predecessor. And it then hires the individuals who, prior to the acquisition, were employed in that trade or business unit. So you might find that you have an asset purchase and it doesn't even fall under these successor rules. You have to see whether you fall into 2004-53 and then determine whether you'd like to use the alternate method, which would allow the successor to issue one W-2 that includes wages paid by the predecessor as well as the successor. That ensures that the employee just gets one W-2, and we would include that in the purchase agreement because it's different than the standard, and the Rev Proc requires the parties to agree to that treatment. So in the purchase agreement, we would note it so it's very clear that both of the parties want to take advantage of the alternate method. Next slide, please. Another issue that we run into pretty often on transactions are issues where a buyer isn't able to immediately provide benefits or payroll to new employees immediately at closing for one reason or another. I think the structure where I see this come up most often is where a company is buying a subsidiary and those employees at the subsidiary are participating in parent payroll and benefits. More concerningly, what we find on transactions is sometimes the business people all agree that, oh, don't worry about it. The seller is just going to keep the employees on payroll and benefits, and we're all going to be fine. The problem is that that can actually create a number of issues. Even if the seller continues to run payroll and benefits, that means the seller's retirement plans could be considered multiple employer plans because these employees, even if they're on the seller payroll and benefits, may be considered for common law purposes to be employed by the buyer. They'll be under the direction of the buyer following closing. And that creates just a whole host of problems, from multiple employer plans for your retirement plans, which means changes to your Form 5500s, non-discrimination testing, and a whole number of things that you're probably not going to do with your retirement plan. The seller's health plans would likely become MEWAs, and even though they would be exempt from a federal filing requirement for MEWAs, they could still be subject to state laws regulating MEWAs. And the parties need to determine how they would handle a number of other issues, like what happens to bonuses that people on the seller's payroll would normally get, should they continue getting them now that they are, buyers' employees? What happens to equity for that period of time? So there are a lot of ways to handle these issues, but none of them are a handshake deal that the employees will just stay on the seller's payroll. It's best to identify this issue as early as possible in a transaction, because I think for all of us, the best possible outcome is that you get seller's payroll and benefits and buyer's payroll and benefits talking to each other, and you actually get the buyer's payroll and benefits stood up at closing so that they're ready to take them on. And that can happen if the parties are really communicating with each other and transferring the information they need. Sometimes what they actually need is they need information on benefits so they can set up mirror plans where they just take the current health plan and they do a mirror copy of it and they flip it. Or they need, a seller's ADP to talk to buyer's ADP, and they say, okay, we can set up a payroll feed and get this up in time for closing. So that's something to think about and talk about up front.
This is one where the HR people really need to get involved.
Yes.
Because it's very practical.
Yeah.
There's legal issues, but the practicalities of making it work are not legal so much.
This is something that the lawyers can't do entirely. We try to facilitate conversations as much as possible, but the HR teams at clients are invaluable in making this happen and trying to avoid this issue. If for some reason you can't actually get the employees transferred over at closing, then I think that's where the three of us come into play more, and we start exploring options for structuring, whether it be some kind of leasing arrangement or a transition services agreement, and you arrange for the seller to formally retain the employees and transfer them at a later date rather than at closing. The transition services or leasing agreement would address things like costs, benefit plan participation, bonus and equity participation, indemnities, how you handle hiring and firing and supervision of employees. And that we closely involve several other practice groups as we negotiate those types of leasing arrangements or transition services agreements. So, obviously the goal is get them all transitioned at closing, but if not, then we really go into what are all the things that we need to tie up to make this an appropriate TSA or leasing arrangement. Next slide, please. Then one other thing that we include in the purchase agreement is Social Security taxes. As I'm sure you're all aware, when an employee becomes employed with a new employer, the employee is treated as a new employee, and the employer isn't allowed to take into account amounts that were previously paid by the employee. This is not an issue, again, in a straight stock purchase where employees remain employed by the same entity. If an employee has already hit their FICA max for the year in a stock purchase, that's fine. They will stay that way for the rest of the calendar year. But where you have a transaction and there are employment transitions, especially in asset purchases, even when employees might kind of feel like they've been employed by the same employer over the course of the calendar year, they have often, in fact, had 2 or more different employers. And that means that they often have FICA withheld by all of those employers with a new FICA wage base each time. And while this all comes out in the wash for them by the time they file their taxes, it does impact their cash flow over the course of the year. And you find that employee dissatisfaction with that FICA restart can be very high. So there are special provisions under Section 3121 that allow a successor employer to take into account compensation paid by a predecessor when determining the wage base. Again, the successor predecessor concept is very similar to what we talked about a few minutes ago. It doesn't cover all circumstances. So if you do, for example, a pre-closing transfer, if you take employees that are employed by a parent and you drop them into a subsidiary, the provision in 3121 doesn't clearly cover that. Though I think a lot of people take the position that if transfer is all in connection with an asset purchase or a sale, that it should broadly cover all of those as well and allow the FICA to roll over. That's another thing that I think we see hotly debated amongst practitioners, and I think we see payroll providers generally take the position that people don't have to FICA restart as often as they might if they've reviewed the regs closely. So that's my thought there, and then I think I'm turning it over to Debbie.
Just very quickly, when we aggregate plans of the buyer and the seller, if the plans come over, we have to be concerned about making sure that both sets of plans continue to satisfy applicable non-discrimination rules, particularly in the context of qualified plans such as 401k plans. There's a special section of the code 410B6C, which is talked about on this slide, which gives a pass for that if the requirements were met immediately prior to the transaction, there's no significant changes in the coverage of the plans, then you can treat the plans as not taking into account other employees of the group for purposes of whether a specific set of plans satisfies the requirements for a period through the end of the second plan year following the plan year in which the transaction closes. Next slide. Another thing that comes up and that is often a surprise is the rules relating to COBRA in the context of a corporate transaction. COBRA, of course, is the rule that says that you have to give people the ability to continue group health coverage if they terminate employment under certain circumstances or otherwise have qualifying events where they lose coverage. In the context of corporate transactions, the COBRA regulations allocate liability for COBRA in the context of the transaction, and they allocate it with respect to M&A qualified beneficiaries is the technical term. Generally, an M&A qualified beneficiary is a person who, prior to or in connection with the transaction, whether it be stock or asset, worked for either the company that's being sold or the assets that are being sold, and the qualifying event occurs on or prior to the transaction. Next slide, please. The regulations apportion the liability between the selling group, which is the seller and all of its 80% owned affiliates, and the buying group, which is the buyer and its 80% affiliates. So long as the selling group maintains a group health plan anywhere in its structure, so anywhere within that 80% aggregated group, the regulations allocate the responsibility on the selling group. If the selling group ceases to provide COBRA coverage anywhere in the 80% owned group, then the obligation to provide the COBRA for the M&A qualified beneficiary shifts to the seller. I'm sorry, if the selling group ceases, it shifts to the buying group. And so this results in, surprise, you now have COBRA liabilities for people that never came to work for you ever, because they had a qualifying event prior to the transaction. You know you've hired some people, but these people come out of the woodwork because now there's no health plan to provide them the coverage. And this is not only a surprise to many buyers, but it also is a surprise to the insurance companies that insure their coverages, because this seems to be a situation where the insurers say, well, we don't have to cover them. They never worked for you.
And sometimes a surprise to the people on COBRA too. They're like, who are you? And why would you give me
Right.
coverage?
And it can also surprise the selling group's insurance company, because if the entity doing the sale ceases to provide its plan, but there's another plan within the controlled group, the 80% owned affiliates, that plan has to pick them up. And so that's also a surprise. So COBRA surprises are rampant in corporate transactions. Next slide, please. Very quickly, our asset sales have kind of been the evil stepsister during this presentation, because we've mostly been talking about stocks, sales, and mergers. But there's a special provision of ERISA that is only for asset sales, and it covers withdrawal liability in the context of an asset sale and withdrawal liability from a multi-employer plan, which is a union-sponsored pension plan for purposes of what we're talking about. In context of an asset sale, the selling employer most certainly is going to have a withdrawal, because they're going to cease to provide contributions to the multi-employer plan with respect to the employees that are being sold. 4204 of ERISA says that if a withdrawal would otherwise occur and there's an asset sale, then there won't be a withdrawal as long as the buyer does a 4204 assumption. Next slide. In order to have a valid 4204 assumption, the purchaser has to have an obligation to contribute to the plan for basically the same number of units that the seller did. The purchaser has to provide a bond to the multi-employer plan for 5 years. And the contract for sale, so our purchase agreement, has to provide that if the purchaser withdraws from the plan within the first 5 years after the transaction, that the seller is secondarily liable. And the important thing here is that if the contract doesn't provide the 4204 language, the 4204 assumption is not valid, it's fatal. So that's why if you're going to do that, we have to make sure that it's put into the purchase agreement. Stephanie, you want to talk about indemnities for a couple minutes?
Yep, I'll take 2 minutes to talk about indemnities. And this is really, I think, probably the last section we'll cover for purchase agreements. Then we'll see if we have a minute or two for questions and your final CLE code. I should mention up front that indemnities typically don't apply in public company deals because there's no one left to actually pay for the indemnity. And Katie already talked about how indemnification is actually very different in rep and warranty deals. It's either totally eliminating seller's liability for breaches of reps and warranties, or substantially limiting their liability for breaches of reps and warranties. However, in other deals where you have just kind of a straight typical, maybe it's not typical anymore, where you have an indemnity for breaches of reps and warranties, where sellers are on the hook for those, you will see kind of a general indemnity that usually covers the benefits reps for some period of time. And what I usually look at is, okay, make sure the benefits reps are included. Are the benefits reps fundamental, which will sometimes have an impact either on the duration of the indemnity or the amount of money available for the indemnity. The benefit survival period ranges anywhere from a specific period of months or years following closing If the deal has, say, a 12-month or 36-month indemnity, then it may follow that. But I'd say often you see the benefits reps actually surviving for the statute of limitations for benefits claims. So, and it'll actually just say statute of limitations in there. And that's similar to the way the tax reps might be treated. And I'd say that more often benefits reps probably aren't fundamental reps, but it's not unusual to see them as fundamental reps either. And then sometimes you will see special indemnities for specific issues. For example, I see that someone in the chat asked about Affordable Care Act issues. You know, if you know you have a very specific issue, you feel you can quantify it, and you need to set aside some money to pay for it because it's something that can't be solved between signing and closing, we do see special indemnities sometimes for benefits issues. Again, not incredibly common, but sometimes it happens depending on the issues that are present in the deal that you're dealing with. So I think we have a couple minutes to look at the questions that have come up.
Yeah.
One of them was insurance coverage on 4204. I'm guessing they're talking about rep and warranty coverage.
Yeah, I have not seen it. And typically that is one of those standard policy exclusions. Any sort of withdrawal liability from a multi-employer plan is typically excluded from the rep and warranty insurance. Again, there's often not reps that are related specifically to the 4204. So again, the rep and warranty insurance really only covers the reps as written. So again, it would really depend on the language used there. And, you know, if there was a specific concern there, you may try to, put in a rep to that effect. But again, that might be excluded as a forward-looking or future rep. So I think it would be tricky to get coverage on that.
And I saw another question on addressing compliance concerns for a buyer in terms of the ACA, auditing and 5500s, et cetera. I think a lot of this is done through the diligence process, getting copies of 1094Cs and 1095Cs, any 226Js they've received, looking at their Form 5500s and any audits they've gotten, and trying to get as much as possible, both so you can uncover issues to the extent that you can uncover them prior to closing, but also so that you can be prepared if issues come up after closing. If you get an employer shared responsibility payment notice, you have the records you need to respond to it and say, why it shouldn't be assessed, what parts of it aren't working. As much information as you can get up front to both help you feel confident that there aren't issues and help you respond to anything that arises later, I think is helpful. But of course, the ACA is one big issue that's still fairly new for deals and one that we all dig into and have had experience representing buyers on as things come up post-closing where, you just can't always know whether there's going to be an issue with the plan.
Right. And kind of the same with the audits and 5500s and, whatever is discovered in the due diligence, how to address it. For example, we've had situations where we know there's an ACA problem and we put in an indemnity for it because we don't know how to address it beforehand.
Yeah.
Another question was about speaking to employees as third-party beneficiaries or enforcement. And I think, Katie, you addressed that vis-a-vis the information we now put in based on the Halliburton case. We try to make sure that they don't have any third-party rights.
Yeah.
I think that's all the questions.
I think so.
So that would wrap up today's program.